Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. If you have been following this podcast from its inception, which we're now over 650 episodes, episode 1 addressed page 1 of the December 29th, 2022 affidavit of probable cause. The most recent episode prior to this one addressed filings of mid-May 2025. I have reported to you multiple filings that have been under seal. I have reported to you numerous hearings that have been sealed and closed to the public. And I'm here today to unfortunately report to you yet another document filed under seal, which raises questions on two separate levels. I'm referring to the May 14th, 2025 Order Sealing Notice of Amended Exhibit List. This court order says, based upon the state's notice of amended exhibit list and motion to seal filed herein, the court does hereby confirm and order that the state's notice of amended exhibit list is exempt from disclosure and are sealed pursuant to Idaho Court Administrative Rule 32 G1 for the reasons stated in said motion. So ordered this 14th day of May 2025, Stephen J. Hippler, District Judge. The first issue relates to what are the reasons stated in the motion. This is a matter that the public is not aware of. What the exhibit list is a listing of all of the exhibits, the things that will be shown or that the state hopes to show at trial during their case in chief, where they are asking this future jury to return a verdict of guilty to the 5 first-degree felonies that Mr. Kohberger is facing at trial. Mr. Kohberger is considered not guilty of all until or unless he either pleads guilty or is adjudicated guilty at trial. A motion, as we have pointed out before, is simply an application from the person or the side who is filing it for a court order from the presiding judge, here Judge Hippler. It is a request, an application. Judge, we would like you to enter an order granting us this or that. Here, it's requesting an order to seal two separate things: the motion itself and the exhibit list amended. So we are, as the public, unaware of why it was that the state of Idaho felt it needed to go to the court to amend. This means they either threw out their prior exhibit list altogether, they supplemented it with more materials, or they amended it by removing certain exhibits. Those are the three general things that it appears would have happened here, applying some sense, speculation based on facts. The second issue that makes this so perplexing is that the exhibit lists were ordered by Judge Hippler in the October 9th pretrial and trial order to be filed under seal, with the hard deadline of April 21st, 2025, which both sides did. The state filed their exhibit list, as did the defense, under seal. So now the perplexing issue, at least for me, is why is the state going back seeking to amend, to supplement, to basically throw out the original list of exhibits and replace it with this one? None of these issues are clear at this time, where so many matters have been withheld from the public from the very beginning of the case. All it takes, ladies and gentlemen, is to look at the case summary page, and you will see multiple entries like this motion to seal, which was filed on May 14th, 2025 by the state of Idaho, and which is now granted by operation of Judge Stephen J. Hippler's order. This is Kathy. Thank you for joining us today.